Okay, there we go, Judge.
Very good. This is DC 19-09729, Guerra versus Pediatrics. Council, before I take introductions of council and before we begin the hearing, allow me to state something for the record. This is a formal proceeding of the 95th District Court. Even though it is being conducted using remote means by Zoom, it is still a proceeding of the 95th, and it is being conducted in compliance with the statutes and the Constitution of the state of Texas, including the open courts provision. As a result, because the public has access to this proceeding by way of the open courts provision of the Texas Constitution, we are broadcasting this on the court's YouTube channel so that the public has access to it, should the public wish to have access to it. And for the record, the way you find out how to get access, you can go to the Office of Court Administration website, and they have a link to all courts that are currently broadcasting at any given moment over YouTube, who are conducting their proceedings remotely but are broadcasting on YouTube. I wouldn't do that if I were on the bench, but I am operating remotely this week. So I'm not on the bench, and therefore I'm not sitting there where the public would have access by walking into the courtroom. The fact that we're doing this remotely, the fact that we are doing this broadcasting on YouTube, creates the reality that parties can create a record on their own by way of recording or downloading the video files. And I have to advise that that is not permitted. Recording of proceedings in the district courts of Texas are not authorized absent an order of the court on any specific proceeding. I have not been asked to, nor have I issued an order authorizing a recording of this proceeding, and therefore the parties and the public are expressly prohibited from recording this proceeding. There's one record that comes out of proceedings in the 95th District Court, and that is the record maintained by the official court reporter of the 95th, Ms. Rouse, who is here and who will report this proceeding. Even though this is a summary judgment proceeding, it's not evidentiary, and there needn't be a reporter's record, so to speak. Having said all those introductories, let me ask for introductions of counsel, starting with Mr. June.
Well, this is John for the plaintiffs, Martha Guerrera, and as next friend of Christian Wires.
Very good. And you may feel free to remain seated. You don't have to stand up. This is a formal proceeding, but no need to stand up considering we're conducting this on YouTube. Ms. Stetler?
Yes, my name is Jessica Stetler, and I represent the defendant, the Pediatric Care Clinic.
All right. Very good. Welcome, both of you, to the 95th District Court. Let me cover a couple preliminary matters based on my review of the proceedings so far. We are proceeding on plaintiff's first amended petition, correct? That is the live pleading?
Yes.
Yes, Your Honor.
Mr. Young?
Yes.
All right. And it was, for the record, that's the petition that was filed August 7, 2020. I do have to make a comment about the first paragraph of the petition. It says that we're conducting this under discovery level 2 because the expedited actions process does not apply because plaintiff is seeking less than $100,000. And I didn't understand that. That is actually contrary to the law. If it's $100,000, it is an expedited action. But I don't think that affects today.
Okay.
As I see, there are 3 causes of action in the first amended petition: premises, ordinary negligence, and gross negligence. Does anyone disagree with that?
I do agree.
All right. Ms. Stetler, does the motion for summary judgment address the ordinary negligence?
Uh, uh, It does in the reply, because ordinary negligence is not available or something you can do in a premise defect case. And I think Mr. June is confused on.
While I agree with that statement of law, I don't think your motion directly addresses that cause of action. I just don't think it addresses it. So I'm going to treat this as a motion for partial summary judgment on the premises and the gross negligence. And if you have to follow up with a motion on the ordinary negligence, it's a simple motion, because Mr. Yoon, unless you have an argument otherwise, I think Keach versus Timberwalk Apartments versus NRA Texas Department of Transportation, Supreme Court has made clear that if it was caused by a defect of the premises, it's a premises case. Do you disagree with that analysis?
I've researched and reviewed some premise liability cases, and the appellate courts, it's a gray area. And this is not where, a boulder was misplaced or there was a hole in the ground. This is having to do with toys that was misplaced and the employee allegedly seeing it. So, it's a gray area. That's why I put that in as an alternative cause of action, Your Honor.
All right. Well, we can address that at a later date. I don't think it's a gray area at all, but fair enough. I'll hear that argument at the appropriate time. Ms. Stetler, 5 minutes to present your motion.
Thank you, Your Honor. This is a premise case. It is a traditional and no evidence summary judgment. The law is difficult for plaintiffs in these cases. They are hard to prosecute, and this case is a good example of that. The time notice requirement for any complaint about an object that you believe to be dangerous being present, there is a time notice requirement for the defendant. And in this case, the undisputed facts show that there's no idea of how long this red plastic Lego piece was on the gray linoleum floor. There's no attempt to try and say how long it would be on there. There's no way to say. It would be sheer speculation. Plaintiff herself admitted that her version of events was that she was barely in the living room of the clinic or the waiting room, that another couple with their child had left right as she walked in, and she wasn't there for more than a minute, perhaps 2 at most, before she walked past the Lego piece she didn't see on the floor, picked up her child, walked back, stepped on it, and fell to her knees. So the motion for summary judgment, without belaboring it, goes through that there's a time notice requirement of how long it had been on there, on the floor, and she cannot meet that in any way. In her response, she provides an affidavit I feel to be completely speculative and inadequate by stating just the remark, "There's no way the receptionist couldn't have seen it," which I think is just sheer speculation on her part. I will say,
I'm going to say, let me say this. Reese, Walmart versus Reese addresses that proximity of an employee does not meet the time notice issue, right. Period. End of story. The Supreme right. Court was very clear on that. So
right. So we've got that issue there. And then also, I think right there, this case deserves a summary judgment. Alternately, the clinic did have a sign up on the back wall, which later, when she took a picture of the area before she left for that day, it's there. But in her deposition, I said, "Did you see that sign?" And this is what it says. And she said, it all happened so fast. I didn't have time. I didn't notice it. And then alternately, I didn't have time to even look around to see if it was there. She was very.
Unfortunately, you just froze up. Unfortunately, this is one of the nuances of remote proceedings.
So we'll just wait, I guess. No?
I don't think she knows she's frozen.
Oh.
She'll come back.
Okay.
All right, I'm gonna step away from, oh, never mind, she's back.
Okay.
Hope we got her. Gentlemen, I don't know what happened to me. I disappeared.
You froze up in mid-sentence and then about 30 seconds later disappeared.
I would say you didn't miss much, but I'm not quite sure where you. I froze. I apologize. I'm on my phone now. Don't ask me what happened. I just was saying that the warning sign was there, and she in her deposition stated she didn't have time or couldn't say if she noticed it or not because it happened so fast. And in her affidavit, she then announced quite clearly that she looked and did not see it, which I think is profoundly different, denying that a sign was there. So I feel that her affidavit's improper because it is right under the sham affidavit thing of clearly contradicting previous testimony. I also would state that the response stating that the deposition excerpt edition, which I think is nice, if not necessary, where she repeated that she couldn't tell if a sign was there or not because she hadn't looked, there was an objection to it because it was not authenticated, but that hasn't been true since about 1994. I looked up the law on that, and the Supreme Court doesn't require authenticating that kind of testimony anymore, that kind of attachment of an exhibit, just like they don't need an authentication for admissions responses or anything else that both parties have ready access to, in discovery materials.
Mr. Yoon, let's address that last issue, the objections as to the deposition transcript. I'm not sure I understand your objections, to be honest. I think it's subsection D of 166A says you can attach discovery products to as long as notice is given. What is the objection to the deposition transcripts?
Well, I'm just saying she has to put in the words, it's a true and correct copy of the deposition transcript, Now, you can overrule my objection.
All right, I'll overrule the objections.
Well, okay, I got like a few other objections too. Now, I guess you can sustain or overrule them too.
Well, I've read I read all the objections, and I read your proposed order on them, and they were all basically the same thing. You were objecting to the deposition transcript. because it wasn't identified as a true and correct copy and because the first page and the last page weren't included, but I don't understand that to be the rule at all, unless you can show me otherwise.
Okay, well, I thought I just throw it in there, but I do have an objection. I'm sorry.
I didn't hear that.
I just threw the objections in there. I'm not sure if
All right.
I'm correct or not, but I put it in there. Now, as for the reply, though.
But before you begin on the reply, I have a question of Ms. Stetler on the summary judgment proof. There's a picture attached that, from what I understand from the motion, was a picture taken by Ms. Guerra.
Right.
And I
Correct.
don't see the warning sign in it, but can you tell me where it is
Yes.
in it?
I'll explain.
Because then I'll tell you this, the photo that you attached that the clinic took is different than the photograph she took of all the signs.
Right. Let me be clear about that. She took a picture, and the original warning sign, which if you look at the type and the setting, it's one of those. My client, the clinic, added a couple of signs after this incident, okay, for a brief period of time before they just removed the toy area. But if you look at her picture, there's a sign on the back wall, and then I did a close-up, and you can see that's the same sign where it says, warning, do not leave children unattended, blah, blah, blah. And she said, well, I said, do you see that piece of paper right there? She goes, I didn't notice it. It all happened so fast. So there is one sign there. And if you look at that distance, she didn't walk up and get close enough to it, but you can see the form and the type and the font and the sort of the lines of print. And there's a close-up, and you can see it's the same sign.
Okay.
So I had to
Mr.
work
Yoon?
with, I had to work with her picture. She didn't get close enough to read it clearly, but you can tell it's the same sign.
Mr. Yoon, your response to the motion?
All right, so, okay, first of all, the reply to the response, she, plaintiffs or defendants counsel attached evidence in there, and, you know, she has to give an additional 21 days notice if she's gonna do that, so I'm gonna ask.
I will sustain that. I won't consider the evidence attached to the reply.
Okay, thank you, Your Honor. Now for the response, okay, this is, there's two elements. It's basically like a no evidence summary judgment. I guess you can consider it traditional too. There's two elements that are challenging. One is that defendant placed the substance on the floor, or whether the defendant actually knew the substance was on the floor or not. In this case, if you look at my client's affidavit, not only was the receptionist facing directly at the toy that was there where my client slipped and fell, my client is saying that the receptionist must have seen it. You know, I think that's a jury question. On top of that, another point is paragraph 5. It says that my client spoke to the receptionist right after the incident, and the receptionist told her that the toys were in that area just a few days prior to this incident. So I think that's a jury question as well, Your Honor. Jury should be able to determine that. As for the signs, on page 56 of the deposition transcript, my client specifically said there were no signs at the moment that she was there. Now, defendant's counsel said there was a small sign somewhere in the back. You know, if there was a warning, a sign, which my client did not see, it still has to be adequate notice. It can't be all the way back there on the opposite side of where the incident happened. So my client didn't get adequate notice of any warnings, Your Honor. So I think this one should proceed to trial, and we should let the jury decide.
Well, let me ask you, have you looked at Walmart versus Reese?
Walmart versus Reese.
How do you get past the Supreme Court saying that a proximity of the employee who must have known that there was ice on the floor because this was right near an ice maker and there was ice always on the floor? How do you get past the Supreme Court saying that does not meet the temporal element? That is, cannot be assumed in a premises case.
I mean, even if the employee is directly facing the dangerous condition, Your Honor?
That's my understanding of Walmart versus Reese. The Supreme Court said there was an employee right there who the plaintiff argued must have known there was ice right there because the employee was standing right next to the ice maker. But the Supreme Court says if you don't have evidence that it existed long enough for the employee to have discovered it, then you haven't met the temporal element for constructive notice.
However, if the defendant placed the substance on the floor, that I think meets the knowledge requirement.
Well, if the defendant placed that Lego there, that would meet the actual notice, but it's not my understanding anywhere in the record, unless you can show otherwise, that the defendant placed that Lego where she stepped on it. Is that in the record somewhere?
No, Your Honor. However, the 5th paragraph of the affidavit does state that the receptionist told her that the toys had been placed in the play area only a few days prior to the incident. So they could have put it there too. Or
Yeah. All right. But what evidence is there that the clinic operated with such wanton disregard for the rights, welfare, and safety of others that it would meet the gross negligence elements?
I can pass on that, Your Honor. I'm not going to go ahead and forget the gross negligence. I can take that out if anybody wants. Or you can grant that. Yeah.
Ms. Stetler, anything further?
No, Your Honor.
All right, I'm going to grant the motion for summary judgment, but it's a partial summary judgment as to the premises and the gross negligence causes of action. As stated a moment ago, I will overrule the main objections to the that were lodged in the response to the motion for summary judgment. I will sustain the objection as to the reply, the evidence that was included with the reply to the response to the motion, but I don't think it was necessary to the court's consideration of the motion. So, Ms. Stetler, if you'd like to prepare an overall order, I would.
I can send to the court. I did propose an order, but it doesn't say partial. So I can send in another one if you like that says partial as to premises and gross, and I'll file another one on the negligence.
All right.
All right.
Very good. And I'll simply point out that I'm on this bench until December 31. So Judge Purdy becomes judge of the 95th on January the 1st. So
okay.
All right.
Thank you very much.
Thank you.
Okay.
Y'all are excused.
Thank you.
Do you want me to stop the stream? I don't.
Yeah,